Estate planning is not only about law and finance, it is also about relationships, memory, identity, and emotion. Beneath every trust document lies a family story. When those emotions are not acknowledged, inheritance can ignite conflict that lasts for years. The psychology of inheritance teaches us that wealth transfer is never purely financial. It carries meaning, it reflects values, it communicates approval, responsibility, and sometimes unresolved tension. When estate planning overlooks this emotional dimension, families often pay the price in litigation and fractured relationships. Inheritance decisions are deeply personal. Parents may view distribution as an expression of love or fairness. Heirs, however, interpret those same decisions through their own expectations and comparisons. What feels responsible to one generation may feel unequal to another. Fairness is often confused with equality. A parent may leave more to a child who managed the family business or provided years of caregiving. Another child may expect an equal division, regardless of circumstance. Without explanation, unequal distributions are frequently interpreted as rejection rather than reasoning. Emotions such as validation, guilt, obligation, and fear of losing control often influence estate decisions. Founders may struggle to transfer authority late in life. Parents may overcompensate for past conflicts through financial gifts. These motivations rarely appear in legal language, yet they surface quickly during estate administration. Conflict often begins with surprise. Unequal or unexpected distributions can trigger suspicion of undue influence. Even justified decisions can appear manipulative if beneficiaries learn about them only after a parent's death. Secrecy, though often intended to prevent tension, tends to amplify it. Long-standing sibling rivalries frequently resurface during probate. Childhood competition and perceived favoritism can intensify under financial stress. Without neutral administration and clear documentation, these rivalries may escalate into formal legal disputes. Blended families introduce additional complexity. Second marriages, stepchildren, and evolving parental roles create competing expectations. If trust language fails to address these relationships directly, feelings of exclusion or threat may follow. In California probate courts, many disputes stem from ambiguous drafting rather than malicious intent. Trusts can serve as powerful conflict management tools. Properly structured, they allow tailored distributions based on need and circumstance. They can avoid probate and public disclosure. They can appoint neutral trustees to administer terms objectively, reducing personal friction among family members. Professional or institutional trustees often provide stability in emotionally complex families. Because they are not personally invested, they interpret and enforce trust provisions without bias. This objectivity can prevent disagreements from escalating into litigation. Understanding the psychology of fairness is essential. Neuroscience research shows that perceived inequality activates emotional responses similar to physical pain. Beneficiaries may feel disinherited even when legal reasoning is sound. Estate planning must anticipate these reactions and address them through transparency. A written statement of intent can be invaluable. When parents explain why certain decisions were made, heirs are less likely to interpret unequal distributions as personal rejection. Clarity transforms inheritance from a silent verdict into a documented expression of values. Generational differences also shape emotional responses. The founding generation often values control, security, and preservation. They may focus on stability and gratitude, but struggle to relinquish authority. The middle generation typically views inheritance as stewardship, balancing responsibility with family harmony. Younger generations frequently connect wealth to purpose. They may prioritize philanthropy, sustainability, or social impact. When estate plans reflect only traditional financial conservatism, younger heirs may feel disconnected. Structured dialogue can align these perspectives and reduce misunderstanding. When emotions remain unaddressed, they can turn into litigation. Claims of undue influence often mask deeper feelings of betrayal or exclusion. A sibling may believe another controlled a parent in later years. A beneficiary may feel erased from the family narrative. California law defines undue influence as excessive persuasion that overcomes free will. Warning signs include isolation of an elder, abrupt changes to estate documents, disproportionate benefits to a caretaker, or secrecy surrounding legal advice. Early legal review and independent counsel are critical safeguards. For families facing high emotional risk, proactive strategies can reduce conflict. Transparent family meetings allow intentions to be explained while all parties are present. Mediated discussions often prevent future misunderstandings. Silence rarely protects relationships. No contest clauses can deter meritless challenges by penalizing beneficiaries who contest an estate without valid grounds. Staggered distributions can encourage maturity and responsibility. Incorporating charitable or educational provisions can unite heirs around a shared purpose rather than competition. In complex family systems, mental health professionals may play a constructive role. Estate planning is ultimately about relationships. Emotional preparation can be as important as financial structuring. Recognizing vulnerability does not weaken a plan, it strengthens it. Experienced estate attorneys must serve as both legal architects and emotional interpreters. They translate motivations into enforceable language. They identify potential areas of resentment before they become disputes. They encourage documentation and communication while preserving confidentiality. Hackard Law has decades of experience representing families in California, trust, and estate disputes. We have seen firsthand that most litigation is rooted in emotional misunderstanding rather than purely financial disagreement. Emotionally aware planning significantly reduces the likelihood of conflict. Every estate plan carries two inheritances. One is financial, the other is emotional. The first sustains lifestyles, the second sustains relationships. Successful planning honors both dimensions with equal care. Practical steps help achieve this balance. Begin planning early before tensions solidify. Include letters of intent explaining key decisions. Select trustees who combine competence with empathy. Encourage ongoing family engagement through shared philanthropic or governance initiatives. Inheritance should not become a battleground for validation. It should serve as a bridge between generations. When planning integrates psychological insight with legal precision, families preserve not only wealth, but also unity. If you are considering estate planning and want to protect both assets and relationships, thoughtful guidance is essential. Hackard Law helps California families navigate the emotional and legal complexities of inheritance with clarity and compassion. To learn more about emotionally intelligent estate planning, contact Hackard Law or visit hackardlaw.com. Your legacy deserves protection not only in financial terms, but in the strength of the relationships it leaves behind. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.